the saga that is the impeachment of Vice President Sara Duterte has been extended for another week. Today, after a caucus, the Senate decided to tackle the Supreme Court's ruling on the VP's ouster case on August 6. Senate President Francis Escudero announced this in today's plenary session. Escudero said this was decided by senators to give them more time to review the High Tribunal's ruling. Last Friday, the SC declared the impeachment of VP Duterte in violation of the one-year bar rule. But according to Senator Mig Subiri, there were senators who wanted to dismiss the impeachment case in Tuesday's plenary session.
For the record, it was agreed in caucus that the matter will be decided upon by the Senate on August 6, 2025, when we open session on that date, in order to afford ample and sufficient time to the members to study the 97-page Supreme Court decision, excluding the concurring and separate opinions filed by 5 or 6 additional magistrates of the Supreme Court.
Meron nakakasama na gusto na yung araw tatayo at i-dismiss na. They gave in to the request of our colleagues na let's give us 1 week, at least 1 more week para pag-aralan na mabuti, and of course our discussions will be educated discussions on the particular issue.
Meantime, the Senate President believes there is no need to convene as an impeachment court again to vote on the Supreme Court ruling. He noted that with the SC's decision, the upper chamber no longer has jurisdiction over the case.
Sa tingin ko, mas safe na Senado ang magpapasya kaugnay nito imbis na impeachment court, dahil baka matingnan pa na paglabag ang pag-convene ng impeachment court matapos ang naging desisyon ng Korte Suprema. Kung inaksyon na namin, at anong itsura namin ngayon na bawal pala lahat ng ginawa namin? Paano kung nag-convict ang Senado? Bawal naman pala lahat dahil nilabag naman pala yung Bill of Rights at right to due process ng nasasakdal. So babalik ta rin ko, Sally. Baka naman kaya minamadali ito noong mga panahon yun ng iba? Ay dahil alam nilang may problema o maaaring magka-problema.
Well, so much has been said about the Supreme Court's ruling on the impeachment case of Vice President Sara Duterte. Let's discuss this tonight from the point of view of a former Associate Justice of the High Tribunal. And joining us is Justice Adolfo Azcuna. Welcome to the Big Story, Justice. Thank you for coming on to the show.
Thank you.
First of all, you have said, Justice, that the decision is lawful but unfair. May you elaborate?
Yes, I said that the decision may be legally correct, but it strikes me as rather unfair. The reason I say so is because the decision crafts a new definition of the initiation of a impeachment complaint, different from the one it has promulgated in the Francisco versus House of Representatives in 2003, wherein a complaint for impeachment is deemed initiated only if it is filed and referred to a proper committee. In this case, there was no such reference to a committee, so it has not yet been initiated. However, now under the new concept or ruling under this present decision, initiation can mean even not referred to a committee if it is archived and then later on deemed terminated and dismissed.
So this sets aside the Francisco ruling. This is the precedent that will be followed now?
Yes, it would amend the Francisco ruling in the sense that it would add a different definition of what is initiating an impeachment complaint.
Now, the House of Representatives Justice is set to file a motion for reconsideration because they say the High Court did not appreciate the facts that they presented in their answer to the High Court. Is there hope for an MR with a unanimous decision of the justices?
Yes, it is the right of the House of Representatives to file a motion for reconsideration. Even if it is a unanimous decision, there's always a chance that they will change, or some of them anyway, will change their votes. And so it's worth trying. Besides, there is also the view that the Supreme Court did not give the House of Representatives a chance to file an answer or even a comment, thereby violating the principle of due process in rendering a decision, which virtually is an ex parte decision.
Ironically, they cite due process as their main argument for deciding in favor of VP Sara.
The main argument is that the fourth complaint is barred by the rule that only one complaint can be filed within 1 year, counting the earlier three complaints as constituting an earlier complaint, even if they do not come within the definition of complaints initiated under the prevailing Francisco doctrine.
And that's exactly what I wanted to ask you, Justice Azcuna, because I've long had an issue with what really happened to the first three complaints. Perhaps the Supreme Court was replying to the non-action of the House or the House Secretary General on the first three complaints, and that's why they deemed it initiated anyways. Because as a citizen, I feel like it's unfair. If I was the one who filed it and they just sat on it for that long. What are your thoughts on that?
Yes, I think the court considered the action of the House in deliberately waiting for the last day to calendar the three previous complaints so that there is no more time to refer them to a proper committee because the Congress was adjourning that day. And instead, they adopted a fourth complaint as a initiated complaint. And so the House, the Supreme Court probably considered that as a bad faith on the part of the House in avoiding referring the three earlier complaints to the committee, and therefore considered it as if they were referred and initiated.
And having said that, Justice, would you say that this action by the Supreme Court actually serves to kind of close some of the loopholes so that the impeachment process will not be taken advantage of down the line in the future?
Yes, I think the action of the Supreme Court is definitely something different from the Francisco ruling. And so I say it should not be applied to the present case because the House merely relied on the same Supreme Court's ruling in Francisco on how a complaint is initiated.
Is it a possibility, Justice, that you will be asked to be an amicus curiae of the court in the House of Representatives or any other petitioner? Will you be
That is the
open?
prerogative of the Supreme Court to ask anybody to assist it as an amicus curiae. I would be honored in such a case.
Justice, on the other side of the coin, because Sean pointed out the move to protect the process, but the process also wants to protect the procedure from fake complaints, from bad complaints. Because once you initiate it to the Justice Committee, once you refer a flawed complaint to the Justice Committee, that's it. The 1-year ban starts. And you're stuck with a complaint that has no future, that can just be dismissed by the committee.
Which is why there was Francisco, the ruling,
Yes.
the Francisco ruling to begin with.
So those are two sides of the coin.
Okay, the reason stated in Francisco why a second complaint within a year, in the case of Francisco within a month, may not be filed is because the incumbent official will have nothing else to do except face complaints for impeachment if you do not limit it as the Constitution provides, not more than one every year.
But there is the matter also of protecting an impeachable official by filing a complaint that holds no water?
Yes, if it holds no water, it should not be referred to a committee. Then it will not be considered in counting the one-year ban.
Then couldn't this have been the argument of the House? That's why it was archived, not referred?
That could be an argument. The problem is they waited until it was the last day. And therefore, it may be considered as bad faith on their part because there was no more chance to refer it on the adjournment already. 10th day was the day of adjournment. If they had done it on the first day, then there's 3 more days to refer it to a committee. They could say that we could refer this, but this has no merit, so we will not refer it. Then they considered in good faith. What the Supreme Court saw probably was a malicious intent not to refer it to committee by calendaring it on the last day when it is impossible already to refer it to committee.
Well, Justice, I wanted to zero in on the due process requirement being cited by the Supreme Court. You are one of the framers of the 1987 Constitution. Is it really required to provide copies of the articles and evidence to the respondent, giving them time to peruse these documents and defend themselves before it is transmitted to the Senate for trial?
I respectfully disagree with that part of the decision of the Supreme Court, which I consider to be as not binding because it is not necessary to resolve the case. No, it's obiter dictum. In any case, very clear to me the provision of the Constitution that in the case where the House itself adopts a resolution by a 1/3 vote, that resolution constitutes already the articles of impeachment, and trial by the Senate shall forthwith proceed. There is no room for asking the respondent to file an answer. Trial shall immediately proceed. The due process and the right to answer will occur in the Senate, where the trial is going to be held.
Now let's go to the Senate, because on August 6, they will discuss this, what their moves will be, Justice. And there are those of the belief, well, Senate President Cheese just said that there is no need for the body to convene as an impeachment court, but rather as a body, as the Senate, to vote on whether they should proceed or not. What should they do? What can they do in this case?
Yes, the Senate now has the option. One is to file a motion for reconsideration. There are also parties to the petitions filed in the Supreme Court. The other is to meet not as an impeachment court, but as a Senate to consider how to proceed in light of the decision of the Supreme Court, whether or not to abide by it or to insist on their prerogative under the Constitution. The Senate should proceed and try the case forthwith.
And what is your position, Justice? What is your belief? What can they do? Can they proceed despite the Supreme Court ruling?
My own concept is for them to abide by the Supreme Court ruling so as not to cause a constitutional crisis. However, it is really up to the senators. They can consider the decision of the Supreme Court as not binding on the present case and apply the doctrine of operative facts, which is that even if it is contrary to the present rule, the old rule should apply because this has already been done, and that there's also a rule that jurisdiction once acquired is never lost. And they said it already acquired jurisdiction pursuant to the prevailing doctrine under Francisco before the Supreme Court decided this case. And so it cannot apply to deprive it of jurisdiction that has already attached. That is, due process requires that you do not deprive vested rights in application of the case.
Yes, Justice. So, kumbaga, it should be prospective or just apply to future cases. But I wanted to go back to the Supreme Court's decision. Some groups have called it as a rushed decision. Would you agree, Justice? And should the Supreme Court have called for oral arguments first, given the weight of the issue?
I agree with that the Supreme Court should have ask for comment, as they invariably did in previous cases, or answer from the respondents before deciding the case merely on the response to questions that it posed, which is not sufficient to allow the respondents to give its full side to the controversy.
Justice, what do you think would trigger a constitutional crisis? If Senate decides to continue with the trial, some legal luminaries don't necessarily think this automatically means a constitutional crisis. So what would it take to bring us there?
I think it could trigger a crisis because the Supreme Court already said that the Senate did not acquire jurisdiction and therefore cannot try the case. So if the Senate proceeds to try the case, you'll have two bodies, independent bodies contradicting each other, and that is not good. That is what is called the pathology of a legal system, when there is not just a violation of peace and order, but there is a violation of the rule of recognition. In other words, the rule of the Constitution is not interpreted in the same way by the branches of government. That is a crisis. That is called pathology of a legal system.
I want to read you something, Justice Azcuna. In a previous interview, you were asked whether or not this was judicial overreach, and you said no, that the Supreme Court really should have studied this case. And you said, I think the Supreme Court is acting within its constitutional power and, in fact, duty to determine whether, in a particular case, any agency or instrumentality of the government has acted with grave abuse of discretion and therefore may be corrected by the Supreme Court through the exercise of its extended power of certiorari. Can you laymanize this for us?
Yes, I said that in relation to its power to ask those questions. But I did not say it should decide on the basis of the answers. It should proceed by requiring a fuller answer and hearing oral arguments, because that is in the light of the concept that the court under the new constitution is given an inquisitorial role. And inquisitorial means take all means to determine the facts. And one of the best way of determining the facts is to hold oral arguments.
All right. Now, Justice, may the court do this when it tackles the MR of the House of Representatives? Will there be an opportunity?
Yes, the MR of the House would give the court an opportunity to allow a fuller discussion of the facts, because this decision depends so much on the facts, what really happened in the House. And this can be done through oral arguments. And not only that, in an oral argument on the MR, an oral argument on the MR will allow a full court, not just unanimous, but a full court, because Justice Kagiwa, who recused himself, is allowed under the rules to take part in the oral arguments. He's not allowed to vote, but he can take part. He can ask questions. And Justice Singh, who is on leave, may participate. Hopefully, she will be able to participate. So you can have a full court listening to the oral arguments, participating, rather than just 13.
And this would be good for the public as well, to be able to observe the arguments of all the sides.
Yes, exactly. The people will also know both sides. And this is, I think, a very healthy exercise that the court, if given the opportunity, should take avail of.
Justice, there are also questions on the timing of the decision on a Friday on the eve of the President's State of the Nation address.
I'm not privy to the timing of the decision or the reasons for it. It is possible that the court wanted the decision to be out before the new Congress comes in.
All right. So we thank you so much. Thank you so much for enlightening us, Justice. And we really do hope you become an amicus curiae. One of the petitioners will request you. Thank you so much. That was former Supreme Court Associate Justice Adolfo Azcuna.